that lasted, for over 60 years. The Supreme Court consistently ruled in that way. And then his ruling, while he tries to make a distinction between, while Roberts tries to make a distinction between his dissent and those older cases, it's very difficult to see it. It's difficult to see it. It's difficult to give it a fair reading and say that, man, it really reads like a bunch of those old Supreme Court cases.
Well, it's that juxtaposition. On the one hand, you have the will of the majority, as it's sometimes expressed by the legislature. Certainly not perfectly. The will of the people is not always expressed by the legislature, but to the extent that it is, you have certain people that at times in history might be subject to oppression due to unpopularity, among other things. So if you look back at the history of this country, there's certainly a legacy of oppression and discrimination along racial lines, and that was essentially used as a justification for allowing Jim Crow to be perpetrated for all of these decades. And it's somewhat similar to the argument that we see today with gay marriage, because the argument essentially is that it's up to the will of the people, and if the will of the people say they don't want same-sex marriage, then they should be able to prohibit it by law. But that was very similar to what was used to justify bans on interracial marriage 50 years ago, 75 years ago, which really isn't that long ago in the scheme of things.
Absolutely, and really giving fair due to the justices back then, many of the justices indicated that they didn't necessarily agree with Jim Crow laws. Well, in Roberts' dissent, he says, well, if I was in the legislature, I'm paraphrasing, maybe I'd vote differently. But I'm not. I'm in the judiciary. And therefore, I'm restricted in how he can vote or how he must interpret the law. He points out that, same-sex marriage isn't in the Constitution, or marriage itself isn't in the Constitution. Therefore, the framers must have left it up to the states.
I have a real problem with that, because I've heard that explanation from a lot of different people. The problem is that the Constitution doesn't specify really anything when it comes to individual rights. It simply says that your life, liberty, and property cannot be taken without due process of law, which basically boils down to liberty being rights, the rights of the individual, can't be taken away unless the state provides some sort of justification for it. And the justification, and this was analyzed by federal courts beforehand when the gay marriage ban was lifted in Florida. The federal district judge ruled, I believe quite correctly, that the state has to come up with some valid reason outside of just moral disapproval, which really was what it was before. It was just moral disapproval over gay marriage. There was no public purpose that was being served by banning it. And if you think about it, and as the judge pointed out there, people had moral disapproval of interracial marriage in past generations. And what I thought that what the judge said was very poignant was that those people had believed in that with great conviction in ways that they don't today. And perhaps in many years from now, people will look back and think how outrageous it was that same-sex marriage was not allowed.
I agree with you 100%. And I'll even go so far as to say that, at times it feels as if we've lost focus as to what power is being granted in the Constitution, right? The power in the Constitution is not being granted to the individual, because fundamentally all power is inherent in the individuals. The power in the Constitution is being granted to the government from the individuals. We shouldn't look to the Constitution for our rights, right? We look to the Constitution for what power does the government have to take away our rights. We give up certain rights to the Constitution. We don't get our rights from the Constitution. That was always a big problem or a big issue when the Bill of Rights was expressed, was that if we express these Bill of Rights, initially these 10 rights, will it seem as if these are the only rights that the individuals have? Because if we express these rights, then if it isn't expressed, then those rights must not exist. Well, no, that's not true. That's not a correct reading of the Constitution. The Constitution grants the government power. It doesn't grant individual rights. So if you're looking for the Constitution for individual rights, you're looking in the wrong place. You have to look in the Constitution for the government's power to take away individual rights.
I think it comes down to the fact that the Constitution and the framers really were, to a large extent, based on Enlightenment thinkers that basically said that if the state is going to exercise power over an individual, if it's going to take away somebody's rights, then it has to be justified.
Right.
The burden is on the state to demonstrate why rights have to be taken away. The burden's not on the individual to demonstrate why they should be able to exercise rights.
Absolutely. And deferring back to the state, or deferring back in this case, when there's clearly been a group that has been singled out, and as the majority rightly pointed out, made their relationships less than. The inability to get married qualifies or constructs a less than relationship. Why should the states be able to do that? What purpose is there in that?
I think that's really the crux of it, because if you're the judge, you're reviewing the case, you say to the state, you say, explain why this is necessary, explain what public purpose is served, and if all you have is moral disapproval, that's just not enough.
Well, I think you and I have talked. Previously we talked about, well, what about polygamy, and
Exactly.
what about other forms of marriage, and I really think there's a big difference between same-sex marriage and a marriage between multiple individuals. And in the case of polygamy, we're not talking of, in the case of marriage, whether you have an individual of a heterosexual couple or a same-sex couple, it's really two people, two meetings of the mind that get together and decide that we're going to join forces as one. In a polygamous relationship, that's not what happens. You have one individual who decides that I'm going to meet the minds with another individual. And then that same individual says, well, I'm going to meet the minds with another individual. And at that point, there are three people involved in this relationship, but the nexus of that relationship hinges on that one person, right? So if that one person is removed from the equation, then that relationship between the three people no longer exists. And there is, in a polygamous relationship, if person A marries person B and person A also marries person C, that doesn't prohibit person B or person C to marry someone else. So we have a chain of relationships that could exist that fundamentally alter the nature of what it means to be in a two-person relationship. Being married to a same-sex person, there's no fundamental alteration in that relationship. Whether it's two men, two women, a man and a woman, it's still two people, two meetings of the mind, and we can say, well, this is how taxes will be filed. This is how property will be separated. This is how everything will be. This is how we want the law to grant these privileges to these two individuals. When you talk about a polygamous relationship, there's a fundamental alteration to the laws that we see that benefit a married couple.
And this is interesting because just last week there was I believe it was in Montana, there was a polygamous family. I think it was one man and I think two or three of his wives that were applying for a marriage license, and he's essentially appealing to the same logic that the Supreme Court had in the same-sex marriage case, saying that the state does not have an interest in stopping him from doing that. It'll be interesting to see if any of the courts take this up and provide a justification. But what you were saying just now certainly is something that could be used to justify it.
Absolutely, because when you start saying, or when you point out that it's not two individuals anymore, and in fact, that the male in that situation, the two females are not married to each other. So it's not a triangle here. This is a this is a line with 3 points on it, right? So there's no relationship between the two females other than their relationship between the male. Now, let's say that the male dies. Well, where is the rights? What right does wife one and wife two have? Who gets the house?
It would dramatically complicate and change a lot of issues with real estate law, with a probate law, that is, what happens after you die, how does property get divided, and it would certainly complicate the tax code quite a bit, because all kinds of tax benefits are conferred to a married couple. What if you have a situation where you have one husband with many wives? Let's say you might have one husband with 10 wives, or you might hear in certain countries even 100 wives.
Yeah.
How is the law going to adjust to that?
It's I mean, it's really it's just not the same. And that is not to say that polygamy or polygamous relationships or polygamous marriage at some point shouldn't be on the table under consideration. But I don't think you can put it in the same category as same-sex marriage. It's simply just not the same.
It's really well, it'll be interesting to see how it develops and what arguments are potentially made. I'd like to get back to John Roberts' ruling, because one of the things that he said that really stuck out at me with respect to same-sex marriage is that by allowing, or rather by requiring that states accept same-sex marriage applications, that the court is now reversing a long-standing tradition that goes back to ancient times, including, among other things, the Aztec Empire, which, as we all know, practiced human sacrifice, and saying, well, the Aztec Empire, they didn't recognize same-sex marriage, the Babylonians didn't, etc. Therefore, that's reason to not do so now. It's just kind of hard to swallow that.
It is. I mean, one of the things that we, as Americans, is celebrate the 4th of July, and we celebrate this great institution of a democratic republic, right? We like to believe in our uniqueness of a nation, right? The uniqueness of our laws, and the plurality of our society, being a melting pot, being the idea that a person, if they work hard, can rise from whatever station they were in life to a station that they may, and many other societies never would have achieved or reached that level of success. So when we start pointing out, the differences in or how older or other societies have done something and trumpet that as a model without any notable benefit to our society as it currently exists today, it just rings hollow. It's, why? Simply saying that the Romans did it or that any other society previously did it, that's not a winning argument.
A lot of those societies were feudal, which is absolutely banned by the Constitution. We're not allowed to have kings and queens, and a lot of those societies were based on monarchies.
Right. I mean, there's no capital market in the Roman Empire as it exists today. So there is something to be said that, we're a little bit different. We're progressive in the sense that we look at, see what benefits society today. What role does government have in our lives? And what are the laws? Are laws designed to impede or promote personal freedom and personal liberty and personal responsibility?
And I think it's really amazing here, especially considering Robert's decision, or rather his dissent to the same-sex marriage proposal, saying that same-sex couples should not have the right to marry. Yet he was really the one that spearheaded the Citizens United case from a few years back. Was the Supreme Court's decision that said that corporations can give unlimited money to candidates under free speech, saying that money equals speech, essentially. The idea that corporations have the same rights as flesh and blood human beings, and that the right of speaking is the same thing as giving money, that is such a stretch, and certainly that's not what the founding fathers of the Constitution probably had in mind when it wrote the Bill of Rights.
Yeah, it's such a tough proposition when we start talking about corporations, because they're not, a corporation's design, its purpose is to make money. And when a corporation deviates from that purpose, then that corporation or the shareholders or the board of directors, open themselves up for liability. That's their purpose, is to make money. It's not to be happy. It's not to have a family. It's not to see, it's to make money, right? They don't make this, corporations don't make decisions based off, their first and primary decision making factor is money, right? And so to treat them as humans, humans, that's not human beings first, only, second, and last factor in deciding what we're going to do,
We're going to have to leave it at that. We have about a minute or 30 seconds to a minute left. I'd like to make sure you have an opportunity to give your contact information out to our listeners.
Well, we're at blindearlaw.com. You can go to www.blindearlaw.com and look us up online. It's so great to be here. This is my second time on the radio with you, Jeff, and I always enjoy it.
It was great having you here. This is Jeff Van Treese for Talk Legal. I'd like to give another special thanks to my guest, Penner Holmes. Please tune in next Tuesday evening from 6 to 6:30. Once again, this is Talk Legal. This is Jeff Van Treese. Thank you so much, and have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information